Noah.
Okay, so good evening, my friends from Brazil. Thanks for being with us. Good evening, my friends from the United States. I mean, good afternoon, because as far as I know, it's 4 o'clock in the afternoon back in Kansas. And so we are very delighted to have today our professors Laura Hines and Professor Christopher Raposa, both educated and trained at the University of Kansas. So let me, without further ado, just introduce them to our audience. Professor Christopher Raposa is the John M. Rounds Professor of Law at the University of Kansas School of Law. He's an associate reporter for the restatement of the U.S. law on international commercial and investor state arbitration and served as a special advisor to the Consumer Financial Protection Bureau for its study of arbitration clauses in consumer financial services contracts. Professor Drahozo, thanks for being here with us this afternoon, evening, and thanks for disposing of your time and for sharing your vast knowledge on arbitration. Professor Drahozo is one of the most reputable professors on this specific field in the United States. So we are very obliged for you because of that. And I'm sure that our audience is really eager to listen to your whatever you can bring to us in this specific field. Thanks, Professor.
Thank you very much. I'm very happy to be here. Appreciate the invitation and looking forward to talking to everyone.
Thank you, Professor. So our other guest is Professor Laura Hines. She is currently the director of the Shook, Hardy, and Bacon Center for Excellence in Advocacy. She was named the Centennial Teaching Professor in 2019, which is not, it's really, I mean, flattering, I imagine. And before joining the Kansas University, Professor Hines was a litigation associate at Washington, D.C. offices of Arnold and Ford and clerked for Chief Justice Donald P. Lay of the United States Court of Appeals for the Eighth Circuit. Thanks, Professor, for being here with us. The work that you have done on issue class action is being is a beacon for the legal environment in the United States. It is a very specific and interesting technical aspect of class actions, and I'm sure that we will learn a lot from you in this webinar. Thanks, Professor, for disposing of your time and sharing your knowledge with us this afternoon, evening.
Well, it is a great pleasure to be here, and I just thank you for the honor of letting me speak with you today.
Okay, Professor Drahosa was with us at the CBMA International Conference on arbitration last year, and we hope as soon as this pandemic recedes, and we hope that this happens, I mean, quite soon, we will certainly have you here as our guest too in Rio de Janeiro in Brazil, and because it would be more than just Brazilian hospitality. This is a duty for anyone who is studying class actions in arbitration. We need to have, I mean, the best of the world here with us, just sharing knowledge and everything. So, my dear friends, I will try to follow strictly the connotations, the two connotations of a moderator, right? Of what a moderator can be. Lately, because of this many different webinars that we are having, sometimes moderators, they just talk too much. I'll try not to do that, even though I'm a lawyer and a professor. So it's not easy. These guys, they are very talkative usually. So, but moderate can be understood as a verb, right? And I'll try to do my best balancing the speeches, but you can also approach the same word as an adjective. And I'll try to be a moderator and not to interfere too much, because my only role here today is to try to get the most out of your vast knowledge on class action and arbitration in order for our audience to really benefit from this unprecedented and very, very interesting webinar, right? So, my friends, I would like to thank Daniel Brantes and Gustavo Schmidt from CBMA for helping us to put this webinar together. And I think, Professor Hines, that we could begin with you. The idea is that you give us an overview of what class action actually is in your jurisdiction specifically, and then I will then we'll go along with Professor Christopher Raposo, and so let's see what happens in between, right? Professor, the floor is yours.
Okay, well, again, thank you so much for inviting me to join you all here today. I'm very excited to talk to you a little bit about American class actions. I mentioned that I had looked very briefly at the Brazilian procedural device and really intrigued by some of the differences. So I'll tell you a little bit about the American one. I'm going to start with sharing with you my, let's see, get this PowerPoint here. Hold on.
We're seeing it all right. Thanks.
You seeing it okay?
Yeah, we're seeing it okay.
Excellent. We're going to start by just talking about what the class action is supposed to do, right? So the idea is that there is a single plaintiff who is representing a group of people who have similar interests. And so it's sort of this extraordinary thing. I mean, I'm sure it's so in Brazil, and it is certainly so in America, that ordinarily litigation is by, one person or maybe a couple individual plaintiffs who are suing a defendant or, several defendants, but everyone is in, all the parties are named, and the litigation is about that whatever violation of law is being adjudicated. The class action is really different because you only really have a plaintiff who is representing other people that are not in the courtroom. And sometimes in America, at least, they don't even know that their interests are being litigated, which is one of the things that's very fraught and problematic sometimes about the American class action. So why do we have class actions? We have them because you can litigate a number of claims by sometimes in America, millions of persons through a representational form of litigation, so that one plaintiff or a couple plaintiffs can represent an enormous group and solve massive claims in a relatively efficient and economical way, as opposed to having each of those people having to bring individual litigation. Mm-hmm. The other thing that American class actions, I think, are both sort of the pride of American class actions and sometimes the bane of American class actions, is the idea that it helps level the playing field, that individual actions that themselves would not really warrant litigation. So maybe there's an antitrust violation and everybody is out $50 or something, right? Some consumer fraud or something, misrepresentation, and a huge number of people have been injured, but no one of them actually has any incentive to bring a lawsuit because their damages are too low. But in the aggregate, all the people who've been injured, if you add up the aggregate harm and the damages done to this class of persons, it actually, it means a lot, right? And so if you allow this class action device to be pursued, then you can vindicate claims of persons that wouldn't otherwise have a role in our justice system at all. Those claims would just go unvindicated, and presumably the deterrent effect of holding defendants accountable for the harms that they are imposing externally on society would then go unresolved and undeterred. So those are sort of the big picture reasons for why we have class actions. But as I said, both of them have within them some of the problems with class actions, because sometimes they're really not efficient, right? Sometimes they can be very complicated and actually just gum up the judicial system and never really get resolved. And so the efficiency, although that is our goal, it is not always achieved. And similarly, at least from the defendant's point of view, often what you hear is that that there is sort of a class action bar, right? A plaintiff's bar that gins up these class actions and finds little tiny harms among a lot of people. And all it really does is give money to the plaintiff's attorneys who make money off these class actions, and sometimes in very large amounts, that I gather are really not the norm in Brazil in terms of attorney's fees, and that the individuals who are purportedly within this class really don't benefit very much at all. And so that's some of the tensions that we have in modern American class actions. I want to tell you a little bit about where the American class action comes from. So it begins, at least its far off ancestors are from England, the 17th century English chancery courts. Unlike the common law courts, the chancery courts, the equity courts began a device called the Bill of Peace, which is sort of, again, kind of the antecedent to the modern class action, allowing group litigation in equity courts. And then, of course, when the United States became a colony, that chancery court system, the equity court system, came to America and was actually in full flourish through the beginning of the 20th century. So in 1938, the common law courts and the equity courts merged together into a single federal court system, and that class action device was brought in to the entire federal judicial system in a rule called Federal Rule 23. And so 23 is still our rule, but it has been, fairly largely revamped. And I'm going to walk you through the rule here in a minute. I just wanted to point out that this is not a recent innovation, the class action. It has actually been around in our sort of Anglo-British past, going back hundreds of years. But obviously in its modern iteration, what we sort of think of today as the class action, is quite evolved from where the Bill of Peace began. Then in 1966, the courts and the academics and the lawyers were frustrated after several decades of some confusion around the class action device, and there was a massive effort to revamp it. And so they revised it in a sort of major modern class action rule in 1966. And the base of that is really what we have today, but there have been amendments over time. So some minor amendments in 98, some fairly minor amendments in 2003, and then a group just more recently in 2018. But the core of the class action rule that was enacted in 66 is really still in place. The later amendment periods really changed the rule in and maybe providing a little more guidance, a little more instruction to courts about various aspects of the class to be considered, like some settlement requirements and things like that. But the core of it is really unchanged since 1966. So let me tell you a little bit about the federal rule. So it's divided up into these 8 sections. I'm not going to go into depth on all of them, but I did want to flag some of the sort of core functions of it. So we begin with the prerequisites, and what this means is no matter what the class action is, it has to satisfy each and every one of these 4 prerequisites, and I'll talk to you about those in a second. Then in section B, it is the kind of class action that the court is certifying for litigation, agreeing that the representational litigation can go forward with that particular kind of class action. And there's three main kinds of class actions, and I'll talk to you about those in a moment too. The third section is about providing notice to class members. And that is particularly important in any time from our federal constitutional due process clause requires that if a court is going to be adjudicating a property interest, then the individual has a right to be notified of that and have an opportunity to be heard, and in the case of B3, to exclude themselves from the class action, to say, I don't want to be part of this. So the notice piece is a fairly important aspect of the class action rule. And then the judgment piece, and I know this is something that is concerned Brazilian class actions as well, which is until 1966, there were some real questions about whether if you have a class action and you adjudicate it to judgment, is that actually binding on all the class members? And there were some real questions about that with some various forms and some courts that kind of were a little reluctant, again, maybe because of the representational aspect of it, really reluctant to impose that on people. But the 66 Amendment had made very clear, and it is, binding black letter law now, that if you have not excused yourself, if you've not excluded yourself deliberately from the class action, and you are a member of the class, then that judgment is binding against you. And so that was sort of an important aspect and innovation of the 66 version of the rule. The D section is really just a bunch of ways that the court is given lots of powers to manage the class action. And then I know another really big difference between American and Brazilian class actions is simply the American discovery system, right? I mean, all of the discovery that's available in individual litigation is available in the class setting. And of course, given that they tend to be, pretty big, complex claims, the discovery part can take, years and, thousands of dollars, hundreds of thousands of dollars. And so D is sort of, just reiterating all the district court powers to conduct the litigation in all kinds of ways, including discovery. The settlement provision of 23E is also fairly unique to the American system, which is once you have certified a class, once a court has agreed to allow the certification, the sort of authorization of a class to go forward, then that class cannot be dismissed or settled without the court's approval. Now that's extraordinary in American litigation as well. Ordinarily, when parties want to settle, they can just privately settle and just say to court, no thanks, we don't need you. We're going to have a private contract resolving our claims. We don't even have to really tell you what the terms of that contract are, right? The settlement is just between the parties in most cases. But in the class setting, the judge is a little bit more active, right? And is required to sign off on that settlement to make sure that the terms of it are fair because of this representational nature, because there's people out there, the absent plaintiffs whose rights are being affected. The court has to actually sign off on them and make sure that those interests are being fully protected. And so a lot of the recent attention in the last 20 years or so has been around these questions about settlement. And one of the ways the rule has changed over time is that it has grown from a very skimpy thing that says the court has to approve a settlement to a pretty elaborate set of instructions to a court about holding hearings and listening to objectors and being told about all related agreements around that settlement. But there's sort of a lot of transparency requirements in the settlements. Appeals is a fairly recent part of the rule as well, which is an acknowledgement that because these cases can take years and years and involve potentially millions of dollars, millions of people, and sometimes the fate of an industry, the determination of whether to certify a class or not certify a class is immediately appealable. Now the appellate court can say, no, we really don't want to take it. But if the parties want, they can skip up to the appellate court immediately and say, this was wrong. They shouldn't have certified it, or they should have certified it. And if the appellate court agrees, if the appellate court wants to do something, then they can step in. Class counsel is the second to last provision, and that's also a relatively recent provision, and it just talks about how sometimes in really big litigation, there are multiple lawyers who seek to represent the class, right? And again, there's a lot of money involved in representing the class, and so we don't necessarily want the first one in the door who might not be as qualified as someone else. And so the rule provides some factors for the judge to consider in determining who is legitimately charged with representing the class as its lawyer. And then finally, attorney's fees. And again, this is another way in which the Brazilian litigation system and the class action system vary quite importantly from the American system, which is there are often very big attorney's fees involved in these cases. The provision here is talking about how the court might go about determining what those fair attorney's fees might be. I mean, it might be that there's a contingency fee agreement that a lawyer gets 30% of whatever the class gets. But the court might, through this provision, look at that and say, oh, that seems like too much, given how little you actually worked and how little, maybe you got for the class. We think a lesser amount that really just reflects the hours you worked or something like that. So again, the court has power over the allocation of attorney's fees to the plaintiff's attorneys. That is, an important constraint potentially on the plaintiff's bar. All right, let me tell you briefly about some of those first couple provisions that I mentioned. So for the prerequisites, these are things that all class actions have to satisfy. You have numerosity, the first one, which just means there has to be enough people in it that joinder is impracticable. So if there's like 12 people, that's not going to be a class. It has to be some number larger than, I'd say, like maybe 40 or 50. But we also sometimes in America have very large multi-party joinders. So it's hard to know how little number you can get away with. I deal in mass torts, and so we really never have to grapple with this. And the rule is fairly broad and flexible. The second one is commonality. And what that says is there needs to be a common question of law or fact that every single claimant in the class would have. You have to find something. It isn't just enough that they're commonly or similarly interested in something. They all have to have a question of law or fact that has to be resolved for their claim that is in common with all the other people in the class, and obviously the class representative. The typicality requirement is just asking whether the person who's seeking to represent that class is typical of the class. And that's sort of a hard thing to measure. Courts are not really all that clear about it, but you want to make sure that somebody is not representing the class on one set of claims, but really they themselves have sort of a slightly different set of claims, or they want a different remedy than the class wants. Something like that, where you see kind of a misalignment, and you want someone who's as typical of the class as can be to represent the class. And finally, the adequacy, which looks a lot like typicality. But it has, again, these sort of due process, these constitutional implications to it, which says that, if that class representative is a sort of too poor a fit, if they have a conflict of interest, for instance, then they are constitutionally inadequate. They cannot represent the class. And sometimes class actions are overturned on appeal, for instance, because a court determines that the class representative that was allowed to represent the class actually was not adequate. And again, often because of a conflict of interest. And so that's an important thing. Now, all of these have to be met. It's not a sort of either or. Each of these have to be met to certify any class. And if you can do that, then I'm just going to tell you briefly about the types of class actions. So the first one is called a necessity class action. I'm not going to get into it too closely, but it is essentially a situation where maybe you have an insurance fund of, I don't know, $100,000. And then you have 1,000 people who think that they're entitled to that fund, but they all think that they get 25,000 of the fund. And so obviously the people who think they have claims to the fund far exceed the fund itself. And so this provision allows you to say, all right, we can't have everybody individually suing against this one corpus, this one fund, because the person who's, in the middle or the end of the line might have a valid claim, but the claim is gone. I mean, the assets are gone by the time they go through. And so the idea is, well, let's put everybody who has a claim against that fund into a class action and then sort it all out, and then everybody will get their fair share of it. The injunctive declaratory relief class action, the B2 class action, is it's probably more familiar to you all, which is simply that, if you want an injunction that says, the government can't do this, or in America, one of the famous ones is school desegregation, or prison reform, an injunction that tells the state of California that they can't have overcrowding in their prison cells, or something along those lines. Maybe an injunctive claim against a polluter to say you have to stop using certain methods that are polluting in violation of our environmental laws. So the class as a whole is seeking an injunctive form of relief, and those are pursued under B2. And the final one, B3, is the sort of the newest innovation. That's the one that really came in 1966, and that's the one that gets the most international and national attention because it's about money. It's where the money is. And so the what's called the opt-out class action, it's called opt-out because what it means is, unlike the first two, in that third one, in this third kind of class action, if you are someone who would have been a member of this class, you can actually tell the court, I don't want to be part of that. I want to sue individually. I don't want to be sued by this representative. And you can, again, you have this constitutional right to exclude yourself. And so that makes it different than the other two. And it is also the people, the framers of the rule, made it clear that this one was not as necessary, right? You really don't need this one necessarily to function, but this is where we get into those questions of access to justice and leveling the playing field and allowing what are called negative value suits that wouldn't otherwise be economical to join together and sue. And they do so under this provision, which is why it tends to be the one that gets the most attention. And it requires what's called the predominance of common issues, meaning not only are there, at least one common issue of law and fact, but there's more commonality, more common aspects of the claims than there are those that apply only to individuals. And then there also has to be a showing of superiority, meaning the court has to find that pursuing this B3 certification, pursuing this class action as a way of adjudicating the dispute is better, is more economical, more fair, more efficient, what have you, than other ways of adjudicating it. So, rather than letting the people go individually or maybe have, again, sort of smaller joinder packages, the court has to decide that it's the best way to go. And so those are the types of class actions that are authorized in B3. And I'm going to tell you just a brief bit about some of the recent Supreme Court cases. So in '96, the Supreme Court had the first opportunity to sort of weigh in on some of the criteria of that predominance and superiority in the B3 class action. And they emphasize that it really is something that needs to be very closely attended to, that you can't just sort of say there's a ton of people. That was an asbestos class action. You can't just say there's a ton of people, they're all interested in asbestos claims, therefore let's have a class action. They really broke it down and said these people have so many different ways they were exposed, so many different injuries, so many different products, so many different defendants, that it's just too vast and complicated, and there is not predominance of common issues. And so they said no to it. And that actually was a pretty big comeuppance to a lot of the cases that had been going on before. In 1999, the court handled that limited fund B1 class action that I mentioned to you. And in that case, they had basically taken one of these asbestos class actions and tried to shove it into the B1 to take away the opt-out problems and not the predominance problems. And the court ended up saying that the limited fund requires that there really be a limit to the fund. It can't just be companies have a lot of money, but the claims against them is even more. And so therefore we have a limited fund. And so they checked the lower court sort of adventurousness in using that B1 form of class actions to get around the problems that the court had. And so therefore we have a limited fund. And so they checked. And then in Walmart, there was an employment discrimination suit adventurousness in using that B1 Walmart form of class actions to get around the problems that the court had. And so therefore we have a limited fund. And so they checked. And then in Walmart, there was an employment discrimination suit adventurousness in using that B1 form of class actions to get around the problems that the court had. And so therefore we have a limited fund. And so they checked that because that's really about primarily injunctive relief. And what these women want is back wages and punitive damages and all kinds of money. And that's just not suitable for certification under the B2 class action. So the courts have been, kind of grappling, the lower courts have been grappling with the implications of these sort of three major Supreme Court cases in the last decade or so. One of the pieces that I mentioned in 2 is an Amgen litigation, which is about securities fraud claims, and Comcast, which was about antitrust claims. And in both of them, they were kind of wrestling with how much the plaintiff had to show at the certification stage, right? So how much evidence, how much do we have to do a damages model or expert testimony? How much does the plaintiff have to show before you even get the class certified to get the class certified? And the defendant, of course, is interested in making the plaintiff have to do a whole lot of work and establish, a lot of facts as much as possible and evidence that is hard to do at the front end of a litigation. And the plaintiffs felt like as long as they could show sort of sufficient evidence to move forward, sufficient evidence to make their claims, that they'll litigate it. And if they don't have enough evidence, then they lose. But you shouldn't make them have to come up with the evidence at the front end. And so that's another piece of the class action landscape that is sort of still, a bit in a bit of flux in America. And then, of course, the last piece that segues into Professor Drahozel's talk for us is class arbitration. And this is it's where the arbitration world hits the class action world, which is that the Supreme Court considered whether claims brought in arbitration could be litigated on a class basis, depending on what the arbitration agreement said. And I know Professor Drahozel is going to speak a lot more about it. I just wanted to flag it as another interesting aspect of class actions and the one that intersects with the arbitration world. I don't know if you want to ask questions now or later.
Professor, first of all, I would like, while you probably stop sharing the slide, I don't know.
Oh, sure.
Okay, no, but I mean, only because we can see you, I mean, in a
absolutely.
Screen and everything. But Professor, first of all, thank you for your very interesting class, I would say, like this, because your effort to stroll with us, to take our hands here in Brazil and go with us from the 17th century with the Bill of Peace and the Chancery Courts and the equity jurisdiction and everything, bringing us up to the famous Conception case in which the not less famous Justice Scalia abrogated the, if I'm not wrong, the Discover Bank versus Superior Court of 2005, and found out that it wouldn't be unconscionable in class arbitration for admitting a waiver of class action and everything. It was amazing. You did this in 26 minutes, which for a law professor takes a lot of knowledge, a lot of talent, a lot of skill. Thanks, Professor. I wish our audience has, enough. They will probably be benefiting a lot from this overview. What actually amazes me in your system of law is its practicality, how straightforward American courts, of course, that is not paradise, of course, that every legal system in the world has its flaws, its problems, its serious issues and everything. But common law really brings me a sense of a system which is more focused on bringing justice to the people than to somehow upholding a whole legal machinery, which is the civil law country. We inherited this not from the 17th century, but from the 9th century Justinian institutes. The Corpus Juris Civili, and some of these things are totally the same nowadays. There was this researcher here that made an empirical research field in which Professor Drahoso is very knowledgeable, empirical research, and he found out that 80% of our current civil code is exactly verbatim like the institutes of the Corpus Juris Civili, which is almost 1,200 years. Far from us. So what I'm trying to say here is that, and if you allow me very briefly, and I think that this will also be seen by Professor Drahoso, is that Brazil deals very differently with class actions. First, because we have in our tradition from a very long time an extremely sophisticated system of joinders and consolidations that allow the legal system to manage, the numerosity and those other features that you've brought up in your speech in a different way. So we've never actually, when it came to, collective rights, individual, homogeneous collective rights, we did have this extraordinarily well needed a system of joinders and consolidations that would help us navigate this rough waters. In Brazil, class actions up to the 80s, I would say, were basically restricted to two kinds. And always impregnated with a heavy ideological and political load. It was with the end of the dictatorship in Brazil around 1984 that we had this constitutional reform, and along with this political movement, some waves of new rights came to light, as for instance, environment, consumer protection. The consumer protection that you in the United States had back in the 60s with Ralph Nader, the environmental movement that you had back with the Declaration of Kennedy, 1966, 1967, if I'm not wrong, I'm sorry if I misguide you as for the dates, but we had here in Brazil in the 80s with, finishing, I would say, with reaching its peak with the new constitution of 1988. At that specific time, our system managed to craft what we call in Brazil class actions, which are, Professor Hines, mind you, undisposable, unrelinquishable, non-waivable lawsuits that usually are presented by the public ministry, which is something that somehow resembles the DA offices and so on, but not exactly. It comes from the French tradition and everything, and usually that's the reason why Professor Drahosa, when he goes on with arbitration and class action, there's a lot for us to discuss. I mean, because after this Scalia decision that were put together with two other previous cases, as far as I know, I mean, the famous trilogy of cases that turned possible you to waive class actions in consumers protection things, and the Consumers Federal Protection Bureau, for which Professor Drahosa works, seems not to be very happy with that thing. Not to mention Senator, well, his name just is slipped out
Sanders.
of my mind. Sanders, yes, that's it. So you have the Congress on one hand and some regulatory agencies on the other hand. And what is very interesting, Professor Drahosa, and I will ask you about this afterwards, is that for you to have stocks listed in the highest corporate governance stock markets here in Brazil, you need companies to have a arbitration executory agreement, a pre-dispute arbitration agreement on their contracts. And as far as I know, in the United States, it's getting really complicated because you have this Arbitration Fairness Act in which they are discussing in Congress what to do and everything. So what I'm trying to bring up here, Professor, it's not really, it's just some sparse, some scattered comments on what you just said. This, of course, translates the need that we have here in Brazil to be discussing comparatively with you from the United States. And please, I will really I'll be a pest on your life because I'll be constantly inviting you to talk in our webinars and everything. But the thing is that it's so different the way that things evolve as far as class actions are concerned. In your country, I mean, not only, I mean, autonomously in your country, but also as a result of the UK tradition and everything, and what happens in Brazil. But since I promised you, and of course I'm breaching my promise now, because to be moderate as an adjective, as to moderate the debate here, and now using it as a verb, Professor Drahosa, the stage is yours for you to, on the segue, go on with your considerations on arbitration and class action. And I cannot promise that I will not pass to you afterwards, as I did with Professor Hines, right? But it would be a pleasure to be listening to your comments and lessons on that. Please, feel free.
Thank you very much. Thank you to Professor Hines for setting the stage so well for me, as well as providing all the useful background on class actions. I think it's probably worth sort of highlighting a couple, well, no, I'll just kind of cut to the chase. American businesses almost uniformly dislike class actions. Now, there's some exceptions. I mean, Professor Hines talked about the sort of settlement issue, and there are advantages to corporations if they can settle all kinds of claims against them in a class action. But I think aside from that, businesses in the United States do not like class actions, okay? And there's a good story behind that and a bad story behind that, or vice versa. The sort of good explanation from the business's point of view is sort of they rely on the sorts of alleged abuses Professor Hines detailed, right? That the money goes to plaintiffs' lawyers, consumers may not benefit, there's some arbitrariness and just sort of confusion that results from class actions. And so the business policy argument is it's a good thing to get rid of class actions in a lot of cases. The bad story is kind of the flip side of the advantages of class actions that Professor Hines highlighted, and that is maybe businesses want to get rid of class actions so they can steal a little bit of money from a lot of people. And $50 from 1 million people is an awful lot of money, okay? And it's really hard to know which of those stories underlies what I'm going to talk about, but for whichever of those reasons or combination of those reasons, It's absolutely the case that American businesses do not like class actions, okay? And so back kind of in the, I guess we can say late 1990s, early 2000s, some lawyers representing businesses figured something out, something that sounds from an American point of view in hindsight pretty obvious, but it was a pretty profound discovery or sort of insight that they had back then. And that is, wait a minute, we don't like class actions. We want to get rid of class actions. Class actions happen in court. If we have an arbitration clause in our contract, the case doesn't stay in court, it goes to arbitration, and lo and behold, we don't have to worry about class actions anymore. Okay. There's a well-known American lawyer named Alan Kaplinsky who is quoted on the right-hand side of the slide, who represents credit card companies in the United States, who has published a number of things saying that, and who credits himself as being the father of class action waivers. It turns out that about the same time, there were a number of other lawyers saying the same things in other industries. But that's kind of the start of my story, is around 2000, businesses started relying on arbitration clauses to avoid class actions. And again, the rationale was class actions are in court. If we have an arbitration clause, we aren't in court, no class action. Okay. Not surprisingly, plaintiffs' lawyers, right, the lawyers for consumers, employees, franchisees, and frankly, even businesses. I mean, several of the US Supreme Court's leading class arbitration or class action and arbitration cases actually involve businesses as plaintiffs, not just consumers and employees. Not surprisingly, they responded, okay? And the response essentially is, as Professor Hines alluded to, well, if we can't have class actions in court and we're in arbitration instead, let's just do class actions or something like a class action in arbitration. And there's some sort of messy legal history behind this, but probably, well, so effective 2010, as the slide indicates, we had a shift from, yeah, you can't have class actions in court, but maybe now you can have something like a class action in arbitration, a class arbitration. The American Arbitration Association adopted rules to facilitate that process. JAMS, another leading American arbitration institution, adopted those rules. And actually, the AAA had over 500 class arbitrations filed before it, really sort of in the last 20 years. So these rules get used, not a huge amount, but certainly some. What's interesting about the rules is the description that Professor Hines gave you of Federal Rule of Civil Procedure 23 in the US federal court rules served as the basis for class arbitration rules adopted by these arbitration institutions. So the AAA's class arbitration rule is very, very similar to Federal Rule of Civil Procedure 23. I think the drafters of the arbitration rules figured, you know, the courts have been doing this for a while. They've identified a bunch of important issues and ways of dealing with those issues. We shouldn't sort of make it up on our own and sort of do it all from scratch. Let's just follow what the courts already have done. And so class arbitration rules were adopted and class arbitration proceedings started to happen in the United States. Okay. Now, turns out businesses didn't like that either. And actually, businesses found out, as a general matter, they like class arbitration even less than they like class actions. Because as Professor Hines indicated in her presentation, if you're unhappy with something a judge does, it's relatively easy to appeal to an appellate court. If you're unhappy with something an arbitrator does, and I'm sure this is true under Brazilian arbitration law, like it is under US arbitration law, it's much harder to get a court to sort of really review what the arbitrators decided. So you're much more likely to get stuck if you're a business with a bad decision from an arbitrator than you are with a bad decision from a court. At least that's the fear, one fear. Okay. Another fear is And this is going to be a very cynical view of arbitrators and judges. So this is an academic talking. So recognize that, okay? But if you look at what the incentives of the decision makers are, arbitrators have different incentives than judges do, right? Judges get paid a flat salary. So if they decide to allow a class action to go forward or not, they get paid the same thing, okay? So there's no strong incentive on the part of judges, at least financially, to find that a case should proceed as a class action, okay? Instead, imagine yourself or sort of place yourself as a very cynical, greedy arbitrator, which I'm sure there aren't any in the real world, but academics kind of talk about these sorts of extreme cases, okay? If you're an arbitrator, okay, how are you going to get paid more money? Are you going to get paid more money deciding, no, we don't want this arbitration to go forward as a class action? Or are you going to get paid more money if you decide, yeah, let's let this thing go forward? Well, the answer is clearly the latter, right? Arbitrations on a class basis are big, expensive undertakings, okay? Arbitrators get paid a lot more with a big, expensive undertaking than with an order dismissing the case. Okay, so there's at least a fear on the part of businesses that the incentives of arbitrators will encourage them to decide that cases should go forward in arbitration on a class basis when judges would not do so. Okay, and I've qualified this a lot by saying I'm being very cynical. There's actually a lot of empirical evidence that supports it. Okay, I'll talk more just briefly towards the end of my talk about this issue, but there's been a number of arbitrations and court cases in which an arbitration clause doesn't say anything about whether class action arbitration is okay, and the arbitrator or the judge has to decide whether to allow that to happen. Arbitrators were much, much, much more likely to say, yeah, let's go forward on a class basis than judges were, which just sort of reinforces this concern on the part of businesses. Okay, so that's all a long explanation for why businesses might not like class arbitration. But in fact, certainly from business lawyers I have talked to in the United States with parties involved in class actions and arbitrations, that's absolutely what I hear. Okay, so all right, businesses figured out how to get out of class actions in court, and it ended up in class actions and arbitration, which they think is even worse. All right, so what do? Well, they start thinking, what can we do to avoid class actions and arbitration? Okay, and this echoes to Jair's point about, can you waive these or not? Well, what's the basis for arbitration? It's a contract, right? The parties arbitrate what they agree to in their contract, okay? And so what lawyers started doing was putting provisions in arbitration clauses saying, we agree to arbitrate, but only individually. You cannot do this on a class basis. Okay, so this is language from AT&T cell phone wireless contract, okay, that essentially says we don't agree to arbitrate on a class basis. And you know, arbitrator, your whole basis for authority to act is our agreement. You can't do this. Okay, and so court said, whoa, wait a minute, you're right. You can't have a class action in court because of the arbitration clause. You can't have a class action in arbitration, a class arbitration, because of this sort of provision, no class relief at all, right? Essentially, the result would be that the party drafting this mass contract, which is what these commonly are, can opt out of class actions. Okay, well, not surprisingly, the plaintiff side lawyers did not take that sitting down, okay? As both Jair and Professor Hines mentioned, there's some Supreme Court cases that address whether these sorts of provisions are permissible, but really the starting point there is not all contract provisions are enforceable, okay? There are just sort of general contract arguments, right? I teach contracts, we're starting class tomorrow. Eventually my students will be learning about some of this stuff, right? You can argue that this provision in the contract, this class arbitration waiver, shouldn't be enforced because it's unconscionable, okay? Which is a common law contract doctrine that basically this provision is so unfair, a court should not enforce it, okay? In the arbitration setting, there's a variation on unconscionability that is, instead of sort of being a general common law fairness doctrine, is based on there being some federal statutory claim right? Some US government adopted, US Congress adopted statutory claim that if the arbitration clause is enforced, couldn't be brought because of some provision in arbitration, here in particular because there was no class action, right? So if you remember Professor Hines saying at the beginning, one advantage of of class actions is that it may let you bring claims that could otherwise not be brought. This effective vindication argument is essentially saying, if you use a class arbitration waiver, it may be uneconomical for claimants to bring these types of claims. And all of a sudden, this federal statute that is supposed to protect consumers or protect employees no longer works because of the arbitration clause. Okay. And so there were courts that would hold arbitration, not the whole arbitration clause initially, but the class waiver provisions either unconscionable or contrary to this effective vindication doctrine. And if the provision's not enforceable, then we're either back in the case of an arbitration going on a class basis, or potentially back in court with a class action. Okay, so by making these contract, you basically see sort of a game of ping pong, right? The ball's going back, tennis, whatever sort of sport you want to think about, where things go back and forth between the sides. Okay, that each side sort of makes progress from its perspective, the other side responds. Here, it's the plaintiff's lawyers making arguments against the enforceability of these class arbitration waivers or no class arbitration provisions, whatever you want to call it. Okay. Well, not surprisingly, businesses had yet another argument they could make in response to this. Okay. This is the AT&T Mobility versus Concepcion case on unconscionability. And there's sort of long background of American arbitration law here that really don't really want to get into too much. But the basic point is there's a federal statute that makes arbitration agreements unenforceable. And the Supreme Court held in Concepcion that statute precludes states from, or courts in general, from using the state law doctrine, right, the California law doctrine, whatever state it is, of unconscionability to invalidate an arbitration clause for waiving class actions. Okay, consumer groups were not happy. If you wanted to read all this small print, it is all basically press articles saying how awful this decision was, because class actions are going to go away. But there was still one argument left, right? This is the unconscionability argument that Concepcion gets rid of. There's also the effective vindication argument. Well, the subsequent U.S. Supreme Court case called American Express versus Italian Colors, also by Justice Scalia, if we want to attribute authorship, essentially got rid of that argument as well. Okay, so and the consumer groups didn't like that either, with one well-known anti-arbitration consumer lawyer describing it as the worst Supreme Court arbitration decision ever. Okay, but for better from the corporation's point of view, or for worse from the consumer and employee protection bar point of view, that's kind of where we are on contract provisions, limiting the use of arbitration, or limiting the use of class actions in arbitration in the United States. That if the company uses an arbitration clause and it includes a provision like the one we saw from the AT&T wireless contract, okay, you don't get a class action in court because of the arbitration clause, and you don't get class relief in arbitration because of the class waiver. Okay. Now that assumes that the whole arbitration clause itself is enforceable for other reasons, or not unenforceable for other reasons. Okay. And more on that in just a second. Okay. But under US law as it now stands, companies can avoid class relief in claims brought by individuals, other corporations, through the use of arbitration plus a class waiver. Now, one note related to Jair's comment, there are procedures in the United States for the government to bring things that look like class actions. And those sorts of claims are not affected by arbitration clauses because the government's not a party to the arbitration clause. So there is still some ability for either injunctive relief, or it doesn't usually work for monetary relief for consumers. It's much more of an injunctive relief remedy. But governments still do have some authority to bring actions against the business. But the private attorney general model that Professor Hines described, where it's an individual claimant represented by the individual claimant's own lawyer acting on behalf of a class, is absolutely something that, at least in a mass contracting setting, businesses can avoid. Okay. Now, they may be getting something else they'd like even worse than all this, which is kind of my last comment that I'll get to in a second. But a couple sort of other sort of open, semi-open issues before I get to that. The first is, what if the arbitration clause doesn't say anything about class actions? Right? I mean, we've been talking about an arbitration clause that says no class actions, no class arbitration. More American arbitration clauses say that, but not all. Okay. What if the contract doesn't, the arbitration clause doesn't address the issue? This is not yet fully resolved, but with a case in 2019 called Lamps Plus versus Varela, the Supreme Court made very clear that if the clause doesn't expressly say class actions are okay or class arbitration is okay, that's not enough to get you into class arbitration. Okay, so there was an earlier case in which the court held that a silent clause wasn't enough. And in Lamps Plus, the court said, well, even if it's not completely silent, if it's ambiguous about whether class arbitration is okay, that's not good enough. The parties have to expressly assent to class arbitration for it to happen. I have actually seen one clause in which parties agreed to class arbitration, but we're talking out of lots and lots of clauses, right? Not surprisingly, parties typically don't agree to it, particularly if it's a business that drafts the clause, which is what is going to be happening here. Okay, so under US law now, even if the arbitration clause does not say no class arbitration, okay, unless it expressly authorizes class arbitration, it's not going to happen. Okay, now that's a big deal for businesses, right? So now they can use arbitration to avoid class relief. Some commentators have argued that, well, that means every business is now just going to use an arbitration clause, right? Which makes some sense, right? They can get rid of class actions by using an arbitration clause. As Brian Fitzpatrick, who is a professor at Vanderbilt Law School, has said, I think he thinks every business would do that. Okay. Certainly businesses that are that face a lot of class liability, potential class liability, are likely to do so, right? Sort of big businesses, Google, like PlayStation, for example, Sony was subject to a class action brought shortly after Concepcion because it had problems with its gaming network. Immediately after Concepcion, it adopted an arbitration clause with a class waiver. And what Professor Fitzpatrick and others have suggested is, well, everyone's going to do that. It's not that simple. And it actually turns out, and the sort of real answer here is it depends. And I'll just sort of skip to this slide as an illustration. I spent a lot of time studying franchise contracts, right? Which is the contract between, let's say, McDonald's parent company and the local person who runs the McDonald's restaurant, okay? Franchisors, the parent company, face a big class action risk because they've got lots of businesses, small businesses they have contracts with. People have argued that every franchisor should include an arbitration clause in its contract. It hasn't happened. These numbers are probably too small to see, but when Concepcion was decided, roughly 40% of the arbitration clauses, the franchise agreements that I studied used arbitration clauses. It went up to 55% in 2016. It then actually declined a little bit, which is totally inconsistent with what the predictions were. It's ticked up a little bit in 2020. I don't have that on the graph because I don't have complete data. Nowhere near 100%. Okay. The Consumer Financial Protection Bureau study that is this glowing green document on this slide, Jair referred to that previously. Similar sorts of numbers, a bigger increase has happened with credit card contracts in the United States. Not every credit card issuer in the United States uses an arbitration clause. And in fact, the vast majority do not, but the big ones do. So what's going on here? Well, the simple explanation for what's going on here is there's a lot more that happens when you agree to arbitration than simply that you get rid of class actions, right? We've already talked, you have less ability to appeal an arbitration award than you do to appeal a trial court judgment. It's just the simplest example. And frankly, it's the one I hear cited most by people I talk to. Businesses that don't face a big risk of class actions and want to appeal bad trial court judgments won't use arbitration, even if it would help them get rid of class actions, because they just don't care that much about it. Small businesses don't care that much about class actions. Big businesses do. Okay. Now, that doesn't mean there might not be a big decline in class actions, right? I mean, if all the big companies, which are the big targets of class actions, use arbitration clauses, that may result in a decline in class actions. But that's different from saying every contract will use an arbitration clause. Final point, and sorry for running slightly over, and that is, remember how we've seen this sort of tennis match, ping pong match going back and forth between businesses doing something, consumer and employees responding back and back. The way things stand as of Concepcion and Italian colors is, right, the winning side is the businesses because they can now avoid class actions. What we've started seeing happening in the last year or two, there's a few of them earlier, but more prominently the last year or two, is typically employment lawyers, or here you can tell Postmates, and we'll see another slide in just a second, DoorDash, which are like Uber, but they deliver food. Okay, there's big issues in the United States about whether their drivers are employees or independent contractors. All of their contracts have arbitration clauses with class waivers. And in addition, what they have, because Postmates and DoorDash and Uber and Lyft all want these to be enforceable, is they have provisions that say, we, the business, will pay all the costs of arbitration, or most of the cost of arbitration. Okay. What some enterprising plaintiffs lawyers have figured out, actually one of whom is a Kansas alum, so we need to pat him on the back. Actually, and Laura, we should have Travis Linkner come in to talk to the law school at some point about this, is if you can get enough individuals lined up and file individual claims, that gives you huge leverage over the business. Because if you've got here Postmates, right, 10,000 individuals, okay? If the business has to pay $2,000 in arbitration fees for each of those individual arbitrations, right? We're talking what? I'm doing my math badly, $20 million, okay? That's a lot of money to pay out of pocket right up front of the case, little or no chance to get it back for a claim that is not likely worth $20 million. So it puts a huge amount of pressure on the business just to settle to avoid paying the arbitration fees, okay? And there's actually a district court opinion involving DoorDash where the judge says, when DoorDash was trying to get out of its arbitration agreement, wait a minute, folks, you agreed to, or you put an arbitration clause in your contract to try to avoid your employee going to getting a class action. They're fine with that. They're not trying to get a class action, right? They're bringing individual claims. That's what you bargained for. Now you realize you screwed up and you're trying to get out of it. It's like, you can't have it both ways, okay? And so this doesn't work in every context, right? The DoorDash drivers are probably easier to organize than credit card customers, okay? But it's put a lot more pressure to try to just created a stronger disincentive to use arbitration clauses to avoid class actions. And it's still too early to know going forward as to how much difference this will make in the use of arbitration clauses with class waivers. But it's been a very interesting development. Let me just leave it that way. Final note, I'm not going to get into this in detail, but Jair, we may want to talk about it. US politics also may have a huge effect on this going forward, depending upon who wins the presidential race and who wins the Senate. Because if the Democrats are in charge, I don't want to say one of the first, but an early thing I think the Democrats would do is get rid of arbitration clauses as a way of, in consumer employment contracts, as a way of avoiding class actions. I think that would happen fairly quickly this time. The House of Representatives has already passed a bill that would do that, but you would need the Senate to switch and then the presidency to switch for it to happen. So, all right. Thank you. Jair, back to you. And sorry for running a little bit long.
No, Professor. Your speech was worth every second of it. Please, you can use all the time you need, because it's really, really interesting what you just brought up, because it's not only, I mean, the code letter of the law and the precedents and everything, but also you've been bringing to us a lot of very thoughtful insights on what goes on behind the legal scenes, the extra legal considerations, which might be so important for us to understand what goes on. And on this note, Professor Hines, I'm getting back to you, because while I was listening to Professor Drahozo, and at a certain point he said, well, arbitration comes out of a contract, right? And he's totally right about that, right? Arbitration, according to Tom Stepanovich, a very fond friend of mine, he says that, and probably many other authors after him or before him, is a creature of contract, right? So, yeah, you're right, but up to what point, and allow me here to make a little joke, right? It's rather naive, but what point a contract can trumps, or maybe Biden's, I'm sorry, Trump's or maybe Biden's, a constitutional warranty. And this is I'm sorry, that's so stupid. But anyways, I couldn't resist that, you know.
Trump is taking on a whole new, Trump is such a natural word to say in that context in the last 3 years.
Okay, but I want to be politically correct, right? So giving a chance to also the Democrats and everything. But anyways, I don't want to interfere in any of your internal affairs and everything, but it was just a joke. Anyways, the thing is, this is exactly, Professor Hines, the situation in Brazil. Not only the whole, this specific kind of class action, which is, by the way, the most popular and the most known kind of class action that we have in Brazil. It's called public action, public civil action, right? It has something to do with this kind of public order or public policy measure that sometimes the government can bring up against certain very, detrimental and predatory practices and everything. But at the same time, it's very different, because here in our country, in your country, you have a wonderful constitution, right? With the 26 or 27 amendments, I'm sorry, 6 or 7 articles. But in Brazil, and it's a life system, so the Supreme Court comes up just updating it all the time and everything, for better or for worse. It's not on us to criticize that, except for scholarly reasons and everything. But the thing is that in our country, in the civil law realm, we always very frequently. I just want to put up the chronometer here, not to exceed my time too. But the thing is, we had a lot of constitutions, and the last one by a specific phenomenon that that scholarly doctrine calls constitutionalism, right? It has somehow civilized, somehow recepted into the constitutional realm some quite ordinary rights. Not the civil rights that we usually expect to be in a constitution, but other ordinary civil or procedimental rights and so on and so forth, by virtue of which we end up not being able to waive it, right, at any possible point. So this is just to bring a note on how this thing works here among us. And now that arbitration is gaining a lot of traction among us, and you are much more realistic about what arbitration might be here in Brazil at this point, because again, we have some waves of new rights coming by and everything. Arbitration is being envisioned as a kind of a Pandora box. Something that is really, good, and there's no detrimental side on it and everything. But the thing is, I keep on thinking, Professor Derhozo, and I'm just teasing you and provoking you to see what would you come up with in your answers. But why the Supreme Court, why the American Supreme Court came up with this decision? I mean, understanding that it would not be unconscionable on those specific circumstances for the party to waive a class action. And before you go further on that, in my opinion, there might be at least three different possibilities. First, in the United States, you have so far a quite activist Congress, I would say maybe progressive, right? Versus a quite formalist, not to say nowadays conservative Supreme Court. So these two great institutions of your wonderful country somehow balance things and try to sort out what the best solution would be. So, for instance, you have the CFPB, the Commission on Financial Protection Bureau, which is really, you have the Dodd-Frank Act, which is really progressive, protective, and everything. You have an attempt of the Congress to come up with a prohibition of mandatory arbitration clauses on financial security contracts and agreements, right? So, and right in the middle, you have this attempt. I've been reading about that, about this investor's choice doctrine. So, whenever the investor would somehow opt in or opt out, so the arbitration clause would. Okay, so these are the news that I've been getting from here. So this is first. Second, Professor Derhozo mentioned some pressure on the business. So at the end of the day, would it be that, bad, or as he told us when he brought up that empirical research, the reaction of the industry was not as, exuberant as it would be expected to be after the 2011, when the Supreme Court interpretation came by, right? So, but again, Professor, isn't there in your system a general good faith clause by which, when parties, aggrieved parties, waive class actions, those very little, very small damages that one might have, like 50 cents, but when multiplied by 20 million, it becomes really big and everything. Wouldn't we be leaving this small amount of money if we just prohibit, or accept the waiving of class action and everything? Wouldn't we be leaving on the table this 50 cents that on the whole would get? And finally, Professor, I told you that thus, since yesterday, I've been very, very distracted. I would say I've been indulging myself by reading your articles, Professor Hines and Professor Derhozo articles. And in one of them, Professor, let me just get to it right now. And this is specifically from 2010. Why do business use or not use arbitration clauses? You and also Stephen Ware, which was the co-author of this study, said that filled out that enforcement of adhesive arbitration agreements benefits the business that use such agreements. And then you go on, the consensus is unsurprising. If businesses using these agreements did not benefit from them, why would they continue to use them? Ask yourselves, right? And then you go on and says, one of us has reviewed empirical studies of arbitration arising out of adhesive contracts, and while noting the limits of such studies, summarize the empirical and deductive picture as follows. Adhesive arbitration agreements give consumers and employees, one, better prices or wages, and two, extra leverage in small yet meritorious cases. But three, reduced leverage in cases that could lead to a big dollar jury award. So what is the explanation for the Supreme Court, professors? And this is a question that I address to both of you, to come up with this decision, very controversial, very complicated, very debatable. And maybe when I pay my phone fees in the United States, they cost me less in the United States than they cost me here in Brazil. And I can't help myself thinking that maybe because when the same AT&T is doing business in Brazil, it somehow trades in the cost of the service, the cost of the class action. And this makes the service to be a little bit more expensive to me. While in the United States, when you pay a little less or significantly less for the same service, maybe it is because the industry is aware that that they will not have to go through class action, so they can spare some money and somehow share this, this bonus with myself. I like to think that Justice Scalia, when he was at home Sunday night, writing his opinion and everything, maybe he had this thing in mind. I don't know. I'm just fancying this. So, my friends, those are my comments. So I'm sorry for being so loquacious. And Professor Hines, if you want to go on first, or Professor Drahozo. Professor Hines, ladies first, right?
Well,
go ahead.
So you raise a lot of really interesting points, and obviously it's partly the intersection. It's the confluence of a long body of law hitting a fairly conservative Supreme Court. You were describing our Congress as progressive, and certainly they have passed a lot of very progressive laws over time, but like the fix to AT&T Concepcion, which Professor Drahozo was mentioning, would be to go in and amend the Arbitration Act and to say there are certain kinds of contracts that are protecting certain fundamental rights, consumer rights, employee rights, and we are concerned about the effect of these arbitration clauses on the enforcement of those rights. And right now, we don't have a will of Congress to do that. I don't know, Professor Drahozo probably has a better sense of any attempts after 2011, or actually even before that, to try to get at that problem. But I just don't think you have enough force behind accomplishing that. I do think that the Supreme Court, and I'm going to defer to Professor Drahozo because this is more his area of expertise, but I think that there's just a very strong sense among the majority of the Supreme Court right now of adherence to this Federal Arbitration Act that's quite old, but is pretty clear about it trumping, as it were, state contract law, and the sort of the embrace of arbitration as a societal good and a legal system that should be protected. And there's also a very strong sentiment in America, and I'm certainly among the majority of the Supreme Court, of this freedom to contract. That at some point there's going to be limits to it, as I said, these unconscionability pieces. But at the end of the day, there's a very strong conservative belief that the power of contract, the freedom to contract, unless you're going to tell me that somebody's had a gun to their head before they signed it, we generally speaking are going to assume that there are reasonable people and they have, willingly consented by entering into these contracts, and we're just simply enforcing the contract. And I think if that's a very strong fundamental viewpoint, then these cases make sense. But I do think I agree with Professor Drahozo that if the political winds turn and the more progressive agenda gets emboldened by a Democratic Senate and a Democratic president, I think you will see the resurgence of more protection on environmental employee and consumer rights.
And I agree with all that. I've always thought Concepcion in Italian colors, the Justice Scalia opinions, I think they're consistent with arbitration law as it went before it. I don't know if they were required by arbitration law as went before it. And I've always thought they're really more about class actions and hostility to class actions than they are about a sort of preference for arbitration. And maybe, Professor Hines, there may be a context you can put that in with other Supreme Court class action cases. And maybe my sort of impression of the court as being anti-class action is oversimplistic. But that's kind of how I've thought of the case as really having more to do with the class action piece than the arbitration piece. And then sort of the other conflict, maybe it's freedom of contract is sort of, it clearly is an important sort of underpinnings of American policy. I think there is also just related to freedom of contract there's just a sort of difference of opinion about how well markets work. Mm-hmm. Jair, your description of, and frankly, some of the, your quote from Professor Ware and I about studies and sort of some of the issues that CFPB had to deal with are how effectively does the market protect consumers, or stated otherwise, if the business inflates prices or sort of overcharges consumers, is there going to be a market sanction? Or conversely, if a business uses arbitration and can charge, do they just pocket the money, or do in fact prices go down? And if you sort of believe strongly that markets work well and governments work badly, you're going to be much more likely to enforce the contract provision, the arbitration clause, the class waiver, and say, we think that's going to save money to the business, and that money is going to get passed down through economic forces to consumers. And so, yeah, some consumers are going to be worse off because they might have won a big jury verdict, but most consumers are going to be better off because they pay less for their cell phone. But conversely, if you don't have as much faith in the market and aren't as optimistic that if businesses are pocketing extra money, that ultimately that's going to end up in the hands of consumers or employees, and you're less trustful of market sanctions such that if the government's not able to, or sort of class actions aren't available, businesses are going to start cutting more corners and engaging in more wrongdoing, then you're going to be a lot more skeptical of what's going on with arbitration clauses and class waivers. And I think that's traditionally how I would have distinguished between sort of the Republicans who tended to, and the Justice Scalias who tended to favor enforcement of arbitration clauses and enforcement of contracts, and Democrats who were much more skeptical and more willing to have government step in and regulate. Interestingly, the one time in recent memory when there has been an all-Democratic presidency, House, and Senate in the United States was 2008 to 2010, right? The first 2 years of President Obama's term. That also happened to coincide with the financial crisis, where I will say, regardless of your views of arbitration, thankfully Congress was spending its time on like saving the economy rather than worrying about these sorts of issues. Although the Dodd-Frank Act, as Jair, you did mention, did a touch on some arbitration stuff, but not as directly as it could have. And as we've discussed, I do think election outcome in November in the United States could change things a lot as far as how this goes. The interesting thing is actually, there are some Republican senators who actually are not big fans of arbitration. So Lindsey Graham actually voted to uphold the CFPB rule that resulted from the report that I've mentioned, even though he's a Republican. I think he may have been, I think there was one other Republican who did as well, which wasn't enough to save the rule from being overridden. Given that the president uses arbitration clauses in many of his contracts, even if the Senate before the election went along with the House to regulate arbitration clauses, I can't imagine the president's going to go along with it. But again, if there's a big shift after the next election, all bets are off.
Well, my dear colleagues, in a quite different way than you are, I'm a professor too. I wish one day I can get to the level that both of you are. But just the same, I would like to thank you very much for being with us this evening now. And Professor Drahoso, I was just wondering about these things. There are many differences between our countries, right? Basically, we are, I mean, the same people. People are the same everywhere, right? But I was listening that after I listen very often to the public system of radio that you have, the PBS, public broadcasting system and everything. And they were saying that after the pandemic, there were around 12 million to 13 million unemployed people in the United States. Of course, this is unfortunate, this is tragic, this is probably the worst crisis that had already affected the United States. But it somehow grieves me to say that before the pandemic, and now we are just, I mean, somehow tending to divide time between the pre-pandemic era, post-pandemic, but something that's expensive. It is so much near, it's so more, it's so closer to the people in a certain way than it is in Brazil, where you can get with pennies, you can get to a court, right? So what I'm trying to say here is that I think that much more than just a webinar, my friends, this session that we are somehow doing for free, because you are disposing of very valuable time of yourselves and everything. So it has a much higher sense. We are getting together with our knowledges, with our experiences. And I like to think that the ultimate goal of this is to build a better world through justice, maybe true. And I dream of the day in which we would really discuss arbitration or litigation or class action in a depoliticized setting, when all our fellow citizens, either in the United States or in Brazil, would be somehow benefiting of the basic commodities of life as food, work, freedom, happiness, and so on and so forth. So I really believe that by accepting our invitation, Professor Hines and Professor Drahoso, you somehow have been doing this, and I wholeheartedly thank you very much for that. And let's try to get together more often. And I know that it's not a big dollar activity. On the contrary, you probably have to waive some big dollar activities to be here. In this sense, it is a big dollar activity, right? But it's worth it. It's so nice when women and men of good faith get together in order to give something, to share something so invaluable as knowledge with others. And I'm sure that our audience here is very thankful for you because of that. Professor Drahoso, please go take care of your very important business, your family and everything. Professor Hines, thank you very much for being with us here. And I hope to see you in the near future, either on screen, right? On screen, or in Rio de Janeiro, in São Paulo, Brazil, or maybe we can
United States.
Yeah,
United States, because a visit of mine to Pepperdine University in California, where I do some activities, is very long. But my dear friends, that's it. Thank you very much, Professor Hines. Thank you very much, Professor Drahoso.
thank you. And I do look forward to continuing this dialogue. I agree with you absolutely, and it would be wonderful to keep this connection and discussion going. So thank you so much.
You're very welcome, Professor. Thank you.
And thank you from me as well. And I couldn't have put it better than you did, Jair. So I'm not even going to try. So thank you for organizing, for hosting, and moderating very moderately for us. And, we'll look forward to seeing everyone again.
That's true. So you take care, my friends. Bye. Best of luck.
Bye. Thank you.